What would possess a man to murder his wife and his son and possibly be involved in other murders? Well, stay tuned because me and attorney Chloe Corbett, we're going to give you a vigorous and thorough legal analysis right after this. Hello, this is Attorney Augustus Corbett, a.k.a. the Minister of Justice. And with me, I have the pleasure of having
Attorney Chloe Corbett, a.k.a. the Duchess of Justice.
And together we're the Defiant Lawyers. Each and every Saturday, we bring you a banging video of a legal analysis concerning policies, politics, personalities, and pop culture to empower you with the information you need to defy this unjust legal system. If you're not a subscriber, I don't know what you're waiting on because this is the hottest legal show on YouTube and we're growing. We are growing. So go ahead, subscribe, like, share, comment, hit the notification bell so that you'll get notified every time we upload one of these banging videos. All right, that said, I am absolutely fired up, ready to go, and ready to do this legal analysis. Chloe, what about you?
Me too. We have a juicy topic today. We're going to be discussing the Murdaugh trial and murder convictions. So I am excited. I missed a couple times, so it feels good to be back. I'm ready to get into it.
Yes, you had almost a slip of the tongue just then, and it's real easy to do because this man's last name is so similar to the word murder. How ironic that is. I mean, the Alex Murdaugh, murder. Man, what an irony. You know, I've never. Well, I have. I've been around many years. You've been around a few years, and we've represented all kind of folks, and but it's just really, really, really sad when someone is convicted of heartlessly murdering his own wife and son. Um, he reportedly shot the son in the stomach with buckshots from a shotgun. And when the buckshots doubled over the son, then he shot the son again in the face with the shotgun. And according to the prosecutor, this is all according to the prosecutor, and the jury believed it, when the mother ran to the son, it was at that time that he shot and killed her. Here's this family: Alex Murdaugh, Paul Murdaugh, Maggie Murdaugh, and Richard Murdaugh. This is the family right here. So much tragedy has hit this family. So much tragedy. Needless to say, all four of these people's lives, two of them are gone. The other two's lives will never be the same. And so we're going to get into how this all came about. And we're going to spend special attention on the trial. A lot of the facts we don't really know because we weren't in the courtroom. And also another disclaimer, we're not South Carolina lawyers, so we can't get into some of the intricacies of the trial, but there are a couple of things that stand out to us as Texas licensed attorney that we're going to discuss with you. It's very different the way they do some things. And Chloe, to show you how the public is engaged in this, my cousin, my first cousin, one of my first cousins, I have many first cousins, but One of my favorite, if not my favorite, first cousin called me yesterday, and we talked about um, a few things related to this trial. And so we're going to get to some things that happened at the trial because a lot of people, I watched it a little bit. I didn't watch it day to day to day like some folks. I mean, it was like almost like not quite on the level of O.J. Simpson, but it's up there. It's way, way, way up there. And so folks were watching this very intently, and some legal questions arose, and I think that we're going to get into some of those today.
Yeah, there was a lot of interest in this case because Murdaugh comes from a family that ran the political and legal system in South Carolina for generations. He was
Well,
a fourth
in that part of South Carolina, I wouldn't say all over South Carolina, but certainly in that region.
right in that region. He's a fourth generation attorney. His father was the solicitor general out there for 30 plus years. His grandfather was a solicitor general for 40 plus years. And I believe his great grandfather was solicitor general as well, which means that they were the top prosecutor in the state. So there's been a lot of, I think that that has also added to why there's a lot of intrigue into this case, on top of the fact that he was accused of killing his wife and his son. So yeah, there's been a lot of interest in in this case, even from the Black community. And look, we're from North Carolina, which is different from South Carolina, but we do have family in South Carolina. I've been to South Carolina a number of times. There's a lot of Black people in that state as well. So eyes have been on this trial and what has happened to him with his convictions.
Okay, so let's dive in. We're going to go back actually to 2015 because the events leading up to this trial started long before the death of the shooting death, the murder of the mother and her son by his father and her husband. So let's just briefly look at some of the background information related to this matter. So on July 8th, 2015, and Chloe, you know more about the facts than I do. Um, but on July 8th, 2015, the body of Stephen Smith, 18, was found on Sandy Run Road in Hampton County, South Carolina. His death was ruled a hit and run, but his family had lingering questions. And 3 years later, February 26th, and by the way, the death of Stephen Smith almost immediately, according to the New York Times, folks began to sort of suspect that the Murdaugh family was involved in this in some way. Now, that has not been established, that has not been adjudicated. So it's all reportedly and allegedly at this point. February 26, 2018, Gloria Satterfield, 57, who worked as a housekeeper and nanny for the Murdaugh family for about a quarter century, died about 2 weeks after she was reported to have fallen on the front stairs of the family's hunting project. So, Chloe, what can you tell us more, if anything, about those two incidents?
From what is being reported, the death of Stephen Smith, I believe it involved one of the Murdoch sons. I believe the older son,
Allegedly.
allegedly, who was never charged with anything.
And
Um, eh,
let me just say, for the record, with the exception of the conviction of Alex Murdaugh, everything else is allegedly. We don't know whether any of this is true, other than the fact that Alex Murdaugh has been convicted. So if we don't use the word allegedly in front of some of these reported facts, this is a running alleged disclaimer.
yeah. So there was allegedly some foul play with one of the Murdoch sons, but nothing came of it. In terms of Gloria Satterfield, she was a housekeeper, I believe, for the Murdoch family for some years. And there's
Yes.
been a lot of questions about her death. And her family is actually suing the Murdoch family, or suing Alex for his alleged role in her death. So there's been a lot of mystery and intrigue and death surrounding this family and questions that have followed Alex Murdaugh leading up to the killing of his wife and son.
February 24th, 2019, Alex Murdaugh's younger son, Paul, the one that he murdered, who was then 19, drunkenly crashed the family boat into a bridge, witnesses said, throwing several of his passengers into the water. The body of one passenger, Mallory Beach, 19, was found a week later. Miss Beach's parents would later sue Alex Murdaugh, bringing pressure on him to reveal details of his finances. And this pressure to bring out financial details was really key in a whole lot of the happenings at the trial. Um, all right, April 18th, 2019, Paul Murdaugh was charged with 3 felony counts in connection with the deadly boat crash. He later pled not guilty. So obviously, they were not able to adjudicate the death of Mallory Beach because Alex murdered Paul. Alex called him Paul when he testified on the stand. All right. So, any additional comments about that, Chloe?
Nothing. It's just that because of all of this death surrounding the Murdaugh family, that's why a lot of questions went into Alex's finances, and we'll get into how he's facing over 100 other criminal offenses related to his alleged financial crimes as well. So there's just been a lot surrounding this family, a lot.
February 24th. Okay, we've looked at that. June 7th, 2021, Mr. Murdaugh, or Alex, called 911 to report that his wife Maggie and son Paul, aka Paul, had been shot at the family's hunting property in Islington, a rural hamlet around 65 miles west of Charleston. June 22nd, 2021, state officials announced that they were reopening investigations into the death of Mr. Smith, the teenager who died in 2015, based on information gathered during investigations into the murders of Maggie and Paul Murdaugh. Okay.
Yeah, going back to June 7th, Murdoch put that call in at 10:07 p.m. and his wife and son, their bodies were found lifeless in the family's dog kennels, as we said on Islington. And reportedly, according to NBC News, he tells a 911 dispatcher, "quote I've been gone. I just came back." End quote. That is going to play a lot into his alibi, and then subsequently some evidence that was found that supposedly um, opposed that alibi. So he's the one that reported his wife and son's death to 911.
And um, talk a little bit about the fact that Alex lied to the police and said that he was not at the dog kennel at the time of the murders, and turns out he had in fact been at the kennel. There was some key evidence that placed him at that kennel. Can you talk about that a little bit?
Yeah, so you know, a lot of experts are saying in our review, if the piece of evidence, which was apparently some audio that was found from Paul that law enforcement recovered, where you could hear just minutes before the killing of Margaret and Paul, you could hear Alex Murdaugh's voice on this recording, and law enforcement was able to pinpoint that Murdoch was actually at the family property, just a couple minutes before the killing of his wife and his son. So without that piece of evidence, it could very well be that Alex will be a free man right now, because that is really the only evidence that was linking him to his home and to the property at the time when his wife and son were killed. There were no, and we'll get into this later, there was no blood. It was all circumstantial evidence. But that key piece of audio that could extrapolate that he was there at the property, that really dinged his credibility and kind of made his alibi go away.
Yeah, he said that he lied to the police about being at the kennel because, as an attorney, he distrusts police officers. Now, when I heard that, I thought that that was a fairly creditable um, reason, actually, that he offered. Because, look, as attorneys, we distrust police officers as well. Okay, not all police officers are dishonest, but we've caught so many police officers being dishonest, and I think the public has seen many police officers who have hidden evidence, who are racist. I go back to the O.J. Simpson trial where the lead investigator, the lead detective, Mark Furman, um, was a huge racist. They found video and audio messages of him using the N word, and that really blew that case up because it was feasible, it was plausible to believe that Mark Furman would plant evidence, blood evidence specifically, in the O.J. Simpson trial if he was on record calling black people the N word, which they were able to find due to good investigation. They did some excellent investigation and found that tape of again the lead detective, a white dude named Mark Furman, calling black people the N word. Um, so in this case, yes, Alex Murdaugh said he was not at the kennel at the time of the murder, but clearly, as you pointed out, Chloe, there is a piece of video where I don't think it showed him, but it you could hear him placing himself at that kennel at that time. But again, I think when he said he lied about being there to the police because as an attorney he distrusts the police. I guess maybe you have to be an attorney to find that plausible, but that's very plausible because again, we have caught many police officers in lies under oath in sworn affidavits, and so I wouldn't trust them either. Be honest with you, I don't trust them for the most part.
Yeah, my thing is, Alex, why are you even talking to the police as an attorney? I mean, we tell our clients every day, you have the right to remain silent. Nothing really truly comes out of talking to the police 9.9 times out of 10. So, in my opinion, he shouldn't have even given spoken with the police directly. Hire an attorney, allow your attorney to do that if you all feel it's necessary to speak to them because that really hurt his credibility. I mean, the fact that
We're
he
going to
lied to the
talk
police.
about. Don't jump ahead. We're going to talk about him testifying in just a minute. But you hit. Well, you're not talking about testifying. You're talking about him just speaking to the police.
Yeah, speaking to the police and lying. I don't think he should have spoke to the police at all. Especially as an attorney, he should know better.
Well, but
And now,
probably because he's an attorney, he thought he could, talk himself out
yeah.
of something. People um, tend to think that they can just talk these investigators and police officers out of something. These police officers and investigators, first of all, are very skilled at what they do. Right? They can mess up an investigation too. Don't misunderstand me. But sitting down and trying to talk your way out of something is likely not going to work. And they can lie to you. I mean, legally, they can lie to you. In fact, in this trial, one of the investigators admitted on the stand to one of the criminal defense attorneys who was representing Alex that he lied to Alex, trying to get Alex to say certain things. He admitted that and said he could. And we as lawyers, we know that the U.S. Supreme Court has specifically said that police officers can lie and detectives when they're doing an investigation. So you're absolutely right. Should have never talked to the police.
Yeah, and the fact that his family has in that part of South Carolina has had so much influence, you know, being the top prosecutors. being involved in politics, extremely wealthy, he probably felt, you know what? He probably felt like nothing was going to come to him because they were so influential in that area. So, these are probably my homeboys. My ancestors have been prosecutors. Prosecutors have a close role with law enforcement usually. So let me go talk to them, boy to boy, man to man, good old boys club. And not thinking about, okay, I really shouldn't be talking to law enforcement in the first place. So I'm sure a lot of that came into play as well.
So the trial. Let's talk about the trial. That's some of the background, but I really want to get to some issues related to the trial. All right.
Real quick before we get to the trial too, that
Yes, ma'am.
people need to know that even before he was indicted with these murder charges, he faced dozens and dozens of other crimes related to financial crimes of him allegedly misappropriating um legal funds from clients, his own private firm misappropriating those funds. As of now, he's facing a total of 100 other crimes beside these two murders. And a majority of those crimes came about even before he was indicted with these two murders back in 2022.
Wow.
I mean, so it's a lot.
Yes, it is. And one of the other things he reportedly did was um, the Satterfield death. There was a huge insurance policy, and um, he allegedly took, that policy. Um, and she had two sons who should have received that money. And I think maybe they ended up getting some, or he promised to give some to them. So he essentially sort of admitted to doing it, and he admitted on the stand he did a lot of these things. So it's you know, wow.
Another thing too, back in 2021, he allegedly hired a man to pretend to kill him in order for a $10 million insurance buyout to be given to his older son. Um, so, that allegedly happened. And then he resigned from his firm and he released a public statement saying that he was going to be entering rehab. And he said, quote, he made a lot of decisions that that he truly regretted. So there's a lot that's going on with Alex leading
Yes.
up even to the trial for the murder of his wife and son.
Yeah. In fact, I read according to the New York Times, his wife Maggie had retained a accountant, a forensic accountant who was going to start looking into the family's finances. So I don't know if that had anything to do with why he murdered her. I don't know if that was his motive. I don't know. The prosecutor is really not required to prove motive, right? They're not that's not a part of what they have to prove. You being a former prosecutor, though, although you don't have to prove it, that the jury want to know what the motive is. You need to kind of connect that dot for them.
Yeah. And people may hear, okay, prosecutors or the state don't have to prove murder, but what about intent? What about the
Don't
person's
have to
mental
prove
state?
motive. Motive. You
Motive,
said
excuse
murder.
me.
Yeah.
I mean, yeah, motive. Um, but what about intent? What is the difference between motive and intent? So, yes, for most crimes, the state does have to prove the person's intent, whether the person committed the act intentionally, knowing they were doing it, knowingly, recklessly, etc. But they don't have to prove motive, which is the why behind why the act occurred. So that's the difference between motive and intent, and what the state has to prove and not.
All right. So let's get into some of this trial. Okay. Some of the things that happened at the trial that we want to comment on. All right. First, this was a circumstantial evidence case. This was a circumstantial evidence case. I take this one. Basically, there was nothing that that connected Alex Murdaugh to these murders. except his voice on that cell phone, on Paul's cell phone video, video from Paul's cell phone. Other than that, there was no gun that connected him to it. No forensic evidence, like none of their blood was on him. No video actually showing him. There was video where you could hear him. There were no eyewitnesses. So this was, a circumstantial evidence case. And a lot of folks in the public think that circumstantial evidence is weak evidence. Well, certainly it's not as good as direct evidence, right? A smoking gun, someone standing over the body, a videotape showing the shooting, an eyewitness, a reliable eyewitness, is those things are certainly direct evidence, makes the prosecutor's job a lot easier. But do not underestimate circumstantial evidence. Prosecutors are very, very skilled at using one brick of circumstantial evidence on top of another brick, 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 and build a complete wall of evidence against someone. So don't underestimate a case because it is circumstantial evidence rather than direct evidence.
Yeah, most people are convicted based on circumstantial evidence. A lot of times, prosecutors don't have the smoking gun or the direct evidence or an actual eyewitness to the alleged crime. So, a lot of cases and a lot of people are convicted solely on circumstantial evidence. So it's not uncommon for a defendant to be convicted of a crime, just like Alex Murdaugh was in this case.
Yeah. And keep in mind, too, that don't, if you all ever serve on a jury, don't shift the burden. The prosecutor has the burden of proving every element of the case beyond a reasonable doubt. It is not the job of the defense lawyers to disprove. It is the job of the prosecutor to prove beyond a reasonable doubt. And so they had that burden, and that's beyond a reasonable doubt. That's a real high standard. And so, like I said, um, they used brick by brick by brick by brick, and there are several things that stand out. Chloe, like we said, things that he said, like you said earlier, things he said when he talked to the police. Can we just stop right there and just emphasize? If you are the subject of a criminal investigation, listen to me very, very, very closely. Let me see. How can I get somebody's attention? Is there something I can do over here? What about that? What about that? Let me do it again. Do not talk to the police or the prosecutor or the detective or child protective services or school officials or resource officer or juvenile detention person. No one, if you are the subject of a criminal investigation. Do not think to yourself, well, if I don't talk to them, they're going to think I did it. And some people think that way, Chloe, knowing they did it.
Yeah.
They know they did it and they still think, well, if I don't talk to them, they'll think I did it. Or if I talk to them, they'll think I didn't do it. Or if I talk to them, they may help me out. And the police are skillful. They'll even tell you that. I want to talk to you because, I want to hear your side of the story, just want to see, what you got to say, we got the other person's story. We need to just hear your side of the story. Don't do it. Don't do it. Don't do it. Don't do it. Chloe,
It's a mistake.
you said something very important earlier. You said there is there is no good that can come from you having that discussion with the police. How true that is. No good. None. None. Zip. Don't do it. I don't know what else to say. Don't do it.
Shut up. Just shut up. Because people, people, how can I say this? Even if you don't make the smoking gun confession, I did X, Y, and Z. I mean, just making an affirmative link between you and this criminal investigation can be your downfall. If an officer is questioning where you were on the night of Monday, and you admit to being in the same vicinity, okay, well, we know that you were there. So now there's some type of link between you and the alleged crime. And it can be those small affirmative links like that.
What were
Those
you
circumstantial links.
what were you wearing?
Exactly. Exactly. So it's just not good. Hire an attorney. If you're in custody and you feel like you're not free to leave, first of all, ask if you're free to leave. That's the first question. And if the police explicitly tell you that you're not free to leave, or if you feel that you're not, even if they do not explicitly tell you, the second thing that needs to come out of your mouth is to ask for an attorney and be quiet after that. Don't say anything more. Because if you ask for an attorney and then later on you continue talking to the police or make confessions, then those subsequent statements can then be used against you. So once you ask for your lawyer, be quiet, shut up after that, and either they will arrest you, you'll go through the process of bonding out of jail, and then you can speak to your attorney, or they'll provide you one then. Whatever, even if you are arrested at that point, still don't say anything, because it's likely going to happen anyway, whether or not you speak to them or not.
That's right. They're still going to arrest you, most likely.
Exactly. Most
So that's
likely.
not going to keep you out of jail. But if you talk and then you hire the lawyer and you did it voluntarily, like Chloe said, and then we file a motion to suppress all the stuff you said that got you in this jam, judge is going to say, no, I'm not going to suppress this because um, they talked voluntarily. But judge, he didn't read him his Miranda warnings. He didn't have to because he was not in custody since your client spoke voluntarily.
Yep.
Folks, listen to us. Please, please listen to us. And this also goes for parents with minors. Don't let your children talk to the police either.
Yep.
Okay? Okay. So we'll move on. Circumstantial case. All right. All right. Murdaugh testifying. I mean, this kind of runs right into what we were just saying. Chloe, go ahead.
Man, a defendant testifying, that's often can be a lot of back and forth between the defendant and his or her attorney. A lot of times, again, people feel like they want to speak and explain themselves and get on the stand and tell their side of the story. And most times, unless there is some type of defense that we have to prove, like okay, so like my dad was saying earlier, the state has the burden to prove that a person is guilty beyond a reasonable doubt. But there are some type of defenses called affirmative defenses where the defendant has to prove that defense. And one of those cases is self defense. So typically, with a self defense case, it may be necessary for the person accused of the crime to get on cases. In most cases, we do not want our clients testifying and getting on the stand to open themselves up to cross examination by the prosecutor. In Mr. Murdaugh's case, he testified.
Chloe, you froze up for about 2 seconds, 3 seconds there. We didn't hear some of what you just said, and it's so important. Just repeat the last couple sentences.
Okay, so if it, most times we don't want our clients testifying on the stand and opening themselves up to cross examination to saying something that could hurt their case. There are times if there's an affirmative defense that we have to prove, such as self defense. Our client is necessary to get on the stand to explain that piece of defense. But in Mr. Murdaugh's case, We saw, if you saw the trial, he testified. And our cousin asked us, well, whether or not it was wise for him to testify, and whose decision is it to testify. We can give the advice to our client not to testify, but at the end of the day, it is up to the person accused. It is their final decision, their constitutional right to decide whether or not they will testify in their own trial. And apparently Mr. Murdaugh made that decision. Um, whether or not it was a good decision, I say I don't believe that it was, because based on his testimony, the judge allowed the state to get into the record that he was facing, and he admitted to all of these financial crimes and the financial fraud that the state could then use as a motive on why he would kill his wife and son.
Now
So
we're
in
gonna.
hindsight,
That's a separate issue that we're going to get into as well. It is really important, the financial stuff coming in like that. We're going to get into that, and I think, is it next? I think it may be next. No, it's not yet next. So we're going to get into that too, Chloe. Yes.
so in hindsight, it may have been good or bad for him to testify, but at the end of the day, it's his right.
Yeah, yeah. When my cousin called, he said, "Well, oh, can he testify even if you all tell him not to?" Yes, like you said, Chloe, it's his case, so he makes that decision. We advise him, and I don't think. I mean, sometimes it may be. I give you the type of case where oftentimes it's necessary, and that's a self defense case, right? So the jury wants to hear from you, period, from a defendant. But most of the time, it's not a good idea. I don't think it was a good idea here at all, period. But in self defense cases, one of the things that has to be proven in a self defense case is that you were in imminent danger. I mean, the jury wants to hear from you, your perspective, what was going on in your mind when you shot the person or when you knifed the person or whatever. The jury wants to hear it from you, and the law requires that they take your self defense case from your perspective. The law requires that you see it through the eyes of the person who shot the other person. So it's almost necessary in a self defense case for a defendant to take the stand. But I really can't think of a good reason why. I'm sure there are, but for the most part, it's not a good idea. And it was not. I saw him testify here, and the prosecutor had a field day. I told my wife they're going to have a field day with him, and they did for 2 days.
Yeah, so that was not a smart decision.
No, I heard his attorneys say that if he didn't testify, the jury was going to um, you know not believe anything he said. Well, the jury wasn't going to believe anything he said anyway. And
Yeah.
I think his attorney said that because they could not disclose their confidential conversations with their client. So they couldn't say, well, we told him not to testify. They couldn't say that. you know. When you're looking at a lawyer represent somebody, um, we have to sometimes look stupid and just take it on the chin. Although we know in our private conversations what we told the client, what we didn't tell the client, but we can't disclose it. We just have to look stupid.
Yeah, man. And according to the New York Times, just about him testifying, um, we had already talked about how he had that alibi, and then the evidence came in where he lied to the police. But that admission came in only after a video confirming his presence, taken by his son Paul, the one who was killed, emerged in court. And reportedly, according to the New York Times, Mr. Murdaugh told the court that he had been at the kennels for a few minutes, but then had left, laying down at the house for a while, and driven to check on his ailing mother who lived about 15 minutes away. He said that he returned about an hour later to find his family dead. So, and then he said, quote, "I lied about being down there and I'm so sorry that I did." Not helpful.
Yes, yes, not at all. All right, so the next thing, Chloe, directed verdict. Um, my cousin asked whether or not the judge could overrule the jury verdict. Um, the answer is yes. Now, again, I don't know about South Carolina law, okay? But here in Texas, yes, the judge can. And in nearly every uh, criminal case where we're representing someone and take it to trial, we ask for a directed verdict. I mean, you know, you're probably not going to get it, but we always ask for it. You know, and that's and that's where we base the directed verdict. Judge, we ask that you would direct a non guilty verdict here. We ask that you override what the jury found, what the jury said happened, what the jury believes happened because of A, B, C, D, E, F, G. For whatever reason, we're asking you to set it aside. Okay. Um, so yeah, we always do that, and the judge has the authority to do so.
And sometimes what we'll do too is after the state rests, we'll ask the judge to dismiss the case by saying that the state has not met its burden to prove the crime beyond a reasonable doubt. Again, that doesn't happen a lot either, but we typically do ask it, one, to for it to be on the record and to preserve appeal, and preserve error. Um, and keep in mind, we talked about this a few videos ago. As defense attorneys, we're always thinking about the record, and a lot of things what we do, even if we
So what do you
suspect that
what do
the
you mean
judge,
by the what do you mean by the record?
so the record is the transcript of what happened at the lower court. So everything that happens, most things are the a court reporter is going to be in the courtroom and is going to be transcribing what is said before the jury, before the judge, etc. And all of that is important because if a defendant appeals a case to an appellate court, there's no new evidence that the appellate court is going to consider. The only thing that the appellate court is going to look at typically is the transcript from the lower court, what happened at trial. So we want to make sure,
As well as the motions and orders and all that too.
yeah, as well as that too. So we're always thinking about, making sure that if we object to something, it's we have it transcribed by the court reporter so that the appellate court can consider it. Because most things, if you don't object to it when it's happening at trial, you can't then bring it up once you appeal the case.
Yeah, great point. So not only a directed verdict, but we also will certainly ask the court to dismiss the case. And for some other reason, we may even ask the court for a mistrial. You know, if something untoward happened. I remember a trial not too long ago. Before we actually started practicing together, Chloe, um, a colleague and I were trying a murder case, what we call a mini cap. Um, it, it's it could have been a capital murder case, but it what the prosecutor was not asking for the death penalty, and the prosecutor got into a back and forth with co-counsel and called him a liar in front of the jury. Called him a liar in front of the jury. Well, that's the basis of a mistrial,
Mm-hmm.
and so those kinds of things happen as well in in trial. So, all right, let's move to the next one. Judge sentencing. Go ahead, Chloe.
Um, so what stood out to us about the sentencing from the judge is, one, the sentencing happened pretty quickly. Again, we're not. licensed in South Carolina, so it may be something that's normal. But typically here in Texas, you have two phases to a trial. You have the guilt innocence phase, which is where the jury or the judge will decide whether or not the person is guilty or innocent. And then you have the sentencing phase, which could occur a month later, 2 weeks later, the next day. It depends, in which sentencing is determined. But it seemed like sentencing happened here pretty quickly. And please correct me if I'm wrong. I believe it happened the next day. Um,
Yes.
so okay, so that stood out, the fact that it happened so quickly. And then, you know, the judge sentenced him to um 2 life sentences without the possibility of parole, and he did it consecutively. So most times judges or juries can hand down sentences that are either concurrent, meaning that they run at the same time, or that they are consecutive, which means the first sentence must run out before the second sentence starts. In this case, the judge, and I can't remember his name, but he sentenced the life sentences without parole consecutively. So in effect, Mr. Murdaugh, if he doesn't win his appeals, I mean, he's going to spend the rest of his life in prison. So that stood out as well. What are your thoughts about the sentencing, Dad?
Yeah, same thing. The consecutive sentences, I want folks to understand that the 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 first life sentence, I presume for one victim, the judge imposed that, and then the judge imposed the second life sentence for the second victim, and then the judge said, "Okay, once you finish the first life sentence, then after you've completed that life sentence, then you must complete the second life sentence." So no one has two lives, not two physical lives. So that basically meant that he would spend his natural life in prison. Another thing that stands out about the judge's sentencing is here in Texas, uh, quite often, it, quite often the jury, the same jury who finds the person guilty, will also do the sentencing. Now that's not necessarily that's not required. Um, we can can choose to have the judge to do the sentencing, and maybe that's what they did, and we don't know. Um, uh, uh, when I say we don't know, we know the judge did the sentencing, but we don't know if in South Carolina law the judge hands down the sentence or decides the sentence, whereas here in Texas the jury recommends the sentence in most cases, but in all cases, it is the judge who imposes it, right? So the jury says this person ought to get this or that. It is the judge who actually enters the judgment and imposes the sentence, I presume, in every state, certainly here in Texas. Um, but it did stand out to me that that the judge actually did the sentencing rather than the jury who found him guilty. Um, because, as Chloe said, it is a separate trial here. Um, the guilt and innocence phase, where they say if you're guilty or not, that's one trial, and then the sentencing is really like a whole nother trial. In fact, you can pick another jury if you like, um, because things change. And my cousin was pointing out, Chloe, that Mr. Murdaugh's the criminal defense lawyers didn't really put up a fight. You know, the judge just began to get into it. I guess I didn't see it, but according to him, he said the criminal lawyers didn't put up a fight, and we here put up a fight. We fight. We fight just like the first part of the trial. We fight. We call witnesses. Call mom, call dad, call son, call supervisor to testify. We beg, we plead, we do what we think is necessary to get the best sentencing possible for our client. So that's another thing that stands out.
Yeah, and I think you told me too, Dad, that I think the judge asked the state why didn't they seek the death penalty?
Yes, that's
Did
another issue. Um, is that coming up? Okay, let's go ahead and talk about it, and then we'll talk about admitting the financial crimes because the judge uh, did that, and we want to talk about that as well. But yes, the death penalty, that's a huge issue, Chloe.
Yeah. It is a little interesting that the judge asked that. Did the judge ask it like on the I guess it would be on the
Yeah,
record
I
in
think it
front
was
of the
on the
jury.
record. I
Oh.
didn't hear it. I didn't hear it. Okay, let me say that. I didn't hear this. This is all hearsay. Um, but no pun intended. But yeah, the judge apparently asked the prosecutors why they didn't seek the death penalty here, and I agree with the judge. Not that I wanted to see Mr. Murdaugh get the death penalty. That's not what I'm saying at all. At all. That's not what I'm saying. Period. Do not take that away. I agree with the judge wondering that because for this reason, most of the people on death row are black. Okay? Most of the folk on death row, and let me qualify that, the sheer number of whites in the country would make most death row inmates whites. So let me say it this way: blacks are disproportionately on death row. They are more likely to get the death sentence. So, had Mr. Murdaugh been a black man who murdered his wife and son, according to the data, there are there's a good chance the prosecutor would have asked for death. And I don't know if that's why the judge raised that issue, but I was wondering the same thing. Not that I wanted Mr. Murdaugh to get the death penalty, but it just why didn't you prosecutor recommend that with such a heinous crime?
Yeah. I mean, that's a good point. And the judge in this case is a African American judge.
That's right.
So maybe he had that same question in his mind. It was reported that, you know, Mr. Murdoch Kid appeared before this judge.
Oh, she locked up again.
It's interesting for the judge as well. The fact that, he because Mr. Murdoch had been an attorney in the same halls of that courtroom to see him then being accused of murdering his wife and son. I mean, that had to be kind of a like, wow, what has he come to?
Yeah.
Just on the psychological side.
Yeah. So I thought it was a good question to raise, or a good issue to raise, because again, blacks, are disproportionately on death row, and they've done, many times they get the death penalty, especially if the victim is white. Um, much more than the other way around. And in Mr. Murdaugh's case, he was convicted of murdering both his wife and his son. So why didn't the prosecutor ask for death in this case? I'm glad they didn't, but um, it was an interesting point. Now the next thing the judge did was, and this is something that we would have been jumping on the tables about, and that is the judge allowed the prosecutor to admit evidence that Mr. Murdaugh committed financial crimes. That was huge. And here's why it was huge. It was huge because, first, it wasn't relevant in my opinion, in the sense that he's on trial for murder. Do the financial documents prove that he murdered someone or not? Now, I can hear prosecutors making a strong argument that, well, the financial crimes show motive. And we would still argue, however, it's not relevant, Your Honor, And number two, and here's how we say it, you all. Here's an actual rule of evidence. We say it this way. We would say, Your Honor, and we would say it just this way, so that, like Chloe said, the record is it's recorded in the record for the appellate court. We would say it because that's going to be an appellate issue. We would say it this way. We would say to the judge that the probative value of you admitting the financial records is substantially outweighed, uh, uh, is substantially outweighed by the possibility of the jury being prejudiced. Okay. In other words, this is prejudicial uh, evidence, financial crimes. They will hear this about the financial crimes, Your Honor, and then they will just assume that, yeah, he committed the murder. If they hear about the financial crimes, then they're going to assume, because that's going to create prejudice in their minds against Mr. Murdaugh. And the only reason that Mr. Murdaugh should be convicted of murder is based on the evidence involving the murder, not whether he committed some other crime. Just because he committed some other crime, some other financial crime, doesn't mean that he committed murder. So if you let the jury hear this, Your Honor, it's going to prejudice the jury, and they're likely going to find him guilty of murder just because he allegedly, and they haven't even proved that, well, he ended up admitting it, but just because he may have or did commit financial crimes. We would have jumped all on the table to keep that evidence out.
Yeah, that is going to be a huge issue on appeal. His attorneys already spoke to the press and said that is going to be one of the big bases on why they're going to appeal his convictions. I wonder if they, I don't know this, but I wonder if they then asked for a mistrial or asked the judge, but the judge allowed it. So I guess not. But I mean, it's just wow. Whatever the prosecutor said must have been very convincing to the judge to allow for the judge to allow the prosecutor to present that evidence. But it is going to be a huge issue on appeal that the appellate courts are going to look at. I'm sure. I don't know whether or not it's going to be enough to overturn the conviction, um, but I know that the defense is going to make a big deal out of it.
Yeah, it goes also to the issue of whether or not it goes to the issue of Mr. Murdaugh's character. Um, and in other words, the rules of evidence are concerned that if you admit character evidence against a defendant, again, that's going to just prejudice the minds of the jury to find him guilty just that's going to cause the jury to say this guy just has bad character. So, yeah, he probably did the murder. I don't have to see any more evidence. As bad as his character is, in other words, if he stole millions of dollars from whomever, then yes, he probably committed murder. So I don't really need to hear anything else. As a matter of fact, the trial is over in my mind. So I'm talking, I'm telling you how a jury could be seriously prejudiced by hearing that. And again, Chloe could say, you know what? I ain't got to hear no more. My mind is made up. If he stole $8 million from that person, whatever, then where there's smoke, there's fire. So he probably did murder his wife and son. I ain't got to hear no more.
In terms of the character, I wonder if the defense opened the door to it. That could be a reason why the judge allowed it in. I didn't watch all of the defense's case. So it could have been possible that the judge felt like they opened the door. I believe that his son testified.
He
His
did.
other son testified about his dad. So
Mm-hmm.
maybe through there, his son could have been like, "My dad is an amazing man. He would never do this." Getting into his
That's
dad's
true.
character,
That's
and
true.
then the judge could have been like, "Okay, well, you open the door to character. I'm gonna let the prosecutor then cross-examine Mr. Murdaugh and bring these other alleged financial crimes in too. So that could have been what happened too.
Well,
And that's one thing we're always concerned about.
expound on that a little bit. I mean, uh, you know, our audience probably most of them have not been to law school. So, what do you mean open the door?
So one of the main things that we're concerned about as defense attorneys is, so you want the jury to see your client as a good person, and you want the jury to buy in into your case theory and what your defense is. But as defense attorneys, what we're concerned about is if our client testifies and talks about their character, or if we bring in like a family member, a friend, or someone who knows our client to talk about how good or honest our client is, then the law says, at least here in Texas, that the state can come back and disprove how honest or how good our client is, and they can bring in a
Well,
I was
what's wrong, Chloe? With because oftentimes you hear lay people saying, "Well, I got this or that person to come and talk about my good character." So, I mean, what's wrong with character coming in the first place?
because then the prosecutor can come back and bring in another person to say, well, no, this person is not honest, no, this person is not good. So the prosecutor can bring in contradictory evidence to prove that your client is not as good of a person as they claim they are, basically.
So, so is there a basic rule that that in a criminal case, characters should not come in?
Yes. um
Yes,
Please don't put me on the spot. I can't remember. I want to say is 404 Texas Rule Evidence.
that's exactly right.
404.
404.
Okay.
All right.
Yeah.
Yeah. That's exactly where we find that 404. You cannot, character is not an issue unless it's an issue in the case. If it's not an element that the prosecutor has to prove, the prosecutor cannot bring forth character witnesses to show the jury that this person has bad character. And oftentimes they do that though by, like they did in this case, bringing in some financial documents or some other act or instance of the person behaving badly. And so they backdoored 404. They actually backdoored it. They got the character stuff in. But as you earlier said, that could also be because the defense open that door. So there is that rule that says you prosecutor can't bring your character in, but if the defense puts on somebody and that person says, "Yeah, this is a great person," that is character evidence, and they just open the door. But you said something earlier when we talked about this before we came on. You said that you all oftentimes as prosecutors will use such evidence because there is an exception to the evidence to the character rule or bad instances and acts, which says you can't you where you prosecutors have said that, well, judge, I'm not offering this to show he has bad character,
Yeah.
right?
And yeah, in Texas, we say we're not offering it to prove this person's character. We're offering it to prove motive or to prove their intent, or to prove something else. And there's certain exceptions. And a lot of times that's how we get character evidence in, based
That's
on one
right.
of those exceptions. I want to read Texas Rule of Evidence 404 for our listeners. It states 404A1 states that evidence of a person's character or character trait is not admissible to prove that on a particular occasion the person acted in accordance with the character or trait.
There it
So
is.
basically, yeah, what that's saying is the prosecutor can't try to bring in a witness or some other evidence to try to say, well, because this person is a bad person on this particular occasion, which we're charging this person with, they acted that way because they're a bad person. They can't do that. But there is an exception in a criminal case that a defendant may offer evidence of the defendant's pertinent trait, and if the evidence is admitted, the prosecutor may offer evidence to rebut it. So
Ah,
that is what I was referring to opening the door.
that's right.
So there you have it.
Yeah. So So the defense attorneys, certainly Chloe and I, would have said, we as soon as the prosecutor said, okay, I want to talk to you about financial objection, judge, objection, and we would have made three objections. We would have said, one, it's not relevant. We would have said, two, it's prejudicial, as we just explained. And number three, we would say this is character evidence. And judge rule however he wants to rule. Okay, however he wants to rule, he ruled that way. And then but it's preserved on the record. And the appellate court will get the chance now to see if the judge made the right decision.
Yeah. Yeah.
And I was also going to say that um, now, although you just read Rule 404 that says the prosecutor can't use character, if the defense can always, however, if the coast is clear, the defense can present character evidence, right? If the person has a clean record and a good reputation and is just an angel, and there are no skeletons out there that would prejudice the jury, then we can do it. But in that case, we ask the clients again and again. We do our own background information. Do you have anything that if we talk about your character, can they come back and impeach you? Because that's what happened. We put somebody up there and said, "Well, you know this person? Yeah, great person, hardworking person. Wouldn't harm a fly. Go to church every Sunday. Pay his tithes. The pastor, somebody. All that." And then here comes the prosecutor. Well, pastor, did you know that in another state he did such and such and such, or in another county? Well, no, I didn't know that. Well, you just like Chloe said, just open the door. That would have never
Well,
came in.
that would have never came in if you didn't put that up there.
Yeah.
Another thing that we can do, I want to tell people that is we can bring in evidence of a person's habit under Rule 406 of the Rules of Evidence,
Oh, you're getting deep
which,
now, girl. You're getting deep now.
yeah.
Oh boy, this is. Go ahead. No, no. Go ahead. This is law school. This is. So we're teaching you all some things here.
So 406 says that evidence of a person's habit or an organization's routine practice may be admitted to prove that on a particular occasion the person or organization acted in accordance with the habit or the routine. So this will come into play where let's say that you're a person that you do something every single day without fail, and people know that you have this habit, and you could say, well, on such and such in the morning I go for a run at Henderson Park every single day at 7 a.m. So there is no way that I was in the vicinity of this of this murder victim. Then we could bring evidence of that habit before the jury and before the court to show that you acted in accordance with that habit as well. So um yeah, that's
That's good.
another big way that we establish that our client is innocent and the
That's
state
good.
can't prove beyond a reasonable doubt their guilt.
That's good stuff, Chloe. Good stuff. All right, we're kind of geeking out right now on the law a little bit. Um, by the way, let me ask you this: the name, it's spelled Murdaugh. You've been saying Murdoch. I've been saying Murdaugh. Which one is it? Is it properly pronounced Murdoch?
I read in a news article that it's pronounced as Murdoch, but
Okay. All right.
I'm
So
not sure.
I trust you. You got the young mind. You do all the research and so forth. So it's probably Murdoch. You're probably right. All right. Okay. All right. Yeah, the admitting the financial crimes, the death penalty, and then the financial crimes themselves. I mean, they seem to be pretty substantial. Chloe, I think you said that you read there are over 100 pending financial crimes that
Yep,
Murdoch still has to face. Is that right?
that's right.
Wow.
Yep. That I mean, think of that's a lot. That's a lot of crimes that he has to account for in trials and pleas and all types of stuff.
Yeah, that
Wow.
is a lot. That is a lot. Like Dave
Yeah.
Chappelle said, a lot. Okay. I think we covered the other things already. Uh, Sentencing to run consecutively. Okay, the appeal. We kind of touched on that. This case is definitely going to the appellate court. Who knows what's going to happen? As you said, Chloe, it's certainly an uphill battle. Um, 80, 90% of the cases that go up on appeal are upheld. The appellate court will uphold, um, especially a jury verdict. I mean, they really, really don't like to overturn a jury verdict unless something egregious happens, some sort of abuse of discretion or some constitutional violation or something. So, um, whether or not the appellate court agrees with the defense that the financial stuff should have never came in, uh, you know, and even then, appellate courts can say, well, yeah, it shouldn't have came in, but it was harmless. You know, there was so much other evidence to show his guilt that yeah, that the judge probably should have kept it out, but it wouldn't have made any difference anyway, most likely. So I mean, they find reasons just to keep it going.
Yeah. I mean, in these financial crimes, Dad, according to the, I wanted to go back to that really quickly because according to the New York Times, the chief financial officer of Mr. Murdaugh's law firm confronted
Chloe,
him.
Chloe, before you get in that, let me just say something real quick. Today, we're going to do something a little different. Before we get off here, if any of you have a legal question, we will try to answer it. And I say try because um, we practice here in Texas. If you ask a Texas related question, we can most likely answer that one. But if you're in some sort of state, now do not do this. Listen to me carefully, folks. We're not going to offer you legal advice um, uh, this way. Okay, that we're not going to do. All we're going to do is perhaps respond to a question and offer general information about your inquiry. It will not be legal advice. We can't offer you legal advice anyway because you're not our client. You haven't paid a retainer, and we wouldn't, even if you were our client and paid a retainer, we wouldn't give you legal advice so thousands of other people could hear it. So do not consider this, and we do not intend for anything that we say during this video to be legal advice. I think we need to probably include a disclaimer below this title thing here, Chloe, so it's understood. We're not dispensing legal advice here at all. We're commenting and offering general information.
Yeah, we're just giving legal information. If you all have a legal question about the way a trial works or any other things related to that nature, we can try our best to answer it. But I just wanted to end on in terms of the alleged financial crimes of Mr. Murdaugh. Um,
We're gonna
the
we're gonna
chief,
take we're gonna take several questions and we're gonna respond to a couple of comments before we end. So you all just hold on right after Chloe finishes. Go ahead, sweetheart.
yes, he was accused of taking about $800,000 in legal fees that was supposed to have been deposited into his firm's account. In addition, prosecutors have accused Mr. Murdaugh of stealing about $8.8 million in all. And he confessed under oath, we talked about this, to many of those crimes, including embezzling about 3.7 million in 2019, which was the same year that his son Paul, he was convicted of murdering, was charged with drunkenly crashing a boat into a bridge, killing one of those passengers. And Mr. Murdaugh maintained that he believes that Paul was killed by an unknown assailant because of his involvement in that crash. Apparently, the jury did not take that theory into account because they did end up convicting him of murder of his wife and his son Paul.
It is. I didn't hear the evidence. I wasn't in court, but I guess it is maybe feasible that someone else did the murder, did these murders. And I say that for a couple of reasons. First, like with going back to O.J. Simpson, they literally found some of Nicole Brown Simpson's blood in O.J.'s truck. They found some, I think, on some of his clothing. Um, the theory that Johnny Cochran and the so-called Dream Team offered to explain that was again because Mark Furman, a racist lead detective, planted that blood on OJ. Why? Because he's a racist. He didn't like this black man being married to this white woman. Um, and keep in mind also there were like four African American women on the jury. There was a lot of racial tension between LAPD and the black community. So many factors were going on with the OJ trial. My point is, they actually found some of her blood on or about OJ. In this case, this is one of the things that the defense team brought out. They had nothing linking him except that video where you hear his voice. But none of her blood. And I heard the defense lawyer say it just doesn't make sense that he did this and then cleaned himself up in such a short period of time. How is it that he was able to clean up after doing these things? No no shoe prints of his. None. I mean, how is that feasible? Which is why I say maybe someone else did it while he was there or under his instruction. Maybe there were more than one person involved. We don't know, but I just thought I'd throw that out.
Yeah, according to the New York Times, the DNA of an unknown man was discovered under Mrs. Murdaugh's fingernails, and law enforcement never found the rifle that they say was used to kill Mrs. Murdaugh, nor the shotgun that they say was used to kill Paul Murdaugh, and there was no blood found in his T-shirt.
Okay,
So,
see that? All right, let's now take a few of these comments. You all, thank you so much for joining us today and for commenting. Coffee Cup says, awesome.
thank you.
Your mother, my wife, she says, welcome. Bianca Simpson said, I saw this on Netflix.
Mm.
Um, Chi or K Chalker asks if it's a particular cousin, I guess, who was talking to me. Um, in my opinion, Murdaugh testified because it was the only way to try to explain the Colonel video. Yeah, I can see that. I can see that. It certainly backfired, as it usually does when you take the stand like that, most likely against his attorney's advice. Samantha Jordan says exactly. I think she was commenting about the financial crimes. Um, she says absolutely that's what happened, I believe. They did. The judge says no mistrial. Someone just gave me a thumbs down. Gee, what happened? What did I say? Whoa, who
Why
did
the
that?
thumbs down now?
I don't know. Man. Uh, uh, Jenny says, so what was his motivation? Yeah, yeah. That's an interesting question. The prosecutor was saying that it was because of all the financial crimes, and the defense lawyers were saying, what does that have to do with his wife? And like I said, I did read in the New York Times that the wife had recently hired, allegedly, reportedly, a forensic accountant who is someone specialized in digging up money and finding financial records and where money went and so on. So I don't know if that is suggesting that he did not want her to discover things and killed her for that reason. I'm not sure. Um, Samantha Jordan says, but they focus more on the financial rather than the proof of him murdering his family. Yeah, prosecutor did that because again, it was just good, impeachable type of evidence, and that's going to be a big appellate issue. That's going to be the crux, I believe, of the defense's appeals case. Samantha Jordan says, but they also, this is when his financial issues started. Okay. And Ms. Domness, it was not allowed in at first, but the defense opened the door. So maybe Ms. Damness watched that and saw that. I don't know. Samantha Jordan says after the boating accident, the girl's family wanted 40 mil. Mm-hmm. I didn't know that, but I know they wanted some money, obviously, for her death, and rightfully so. If if Paul was negligent, careless, or intentional in his behavior, the housekeeper and the housekeeper said she wanted his was this clothes,
She
and there
washed his clothes.
she washed his clothes and there was no blood. Okay, okay. See, we got some tuned in listeners here, Chloe. They were
Yep.
watching that trial. Um, Pam says, love this analysis. Super special. Father and daughter team. Okay.
Thank you, Pam.
I like that. Ooh, ooh, ooh. Yeah. And Margaret Bingham said, wake up. Wake up. I don't know what Miss Bingham is referring to, but we appreciate the comment nonetheless. Okay, so thank you all. Apparently, there are no questions, no legal questions, which is good. So there's no chance of us, Chloe, getting in any trouble. So someone saying, I heard you all,
We
and
got
y'all
another
said,
comment that,
oh, there's another comment.
yeah, L. Witz. I don't care what people say. Alex's testimony was technically flawless and he wiped the floor with waters. Okay.
Okay, all right. So this
Thank you for that
person,
comment.
yes, this commenter thinks that Alex gave good testimony.
He would have
Uh,
wanted you on his jury.
Definitely, yeah. Just one of you,
Just one of you.
which is a great point. That the defense just needed one person to doubt the state's case, and apparently, Alex's testimony did not do it for that jury. They just didn't do it, and they went in there and heard all the evidence. So, just saying. Yes, absolutely. Thank you. Thank you. Thank you for your comment. All right. So,
Why, all of you all who are up here, please like this video. If you enjoyed this discussion, this
well,
information, share
Chloe,
this video.
one more comment. One commenter
Okay.
disagrees with Mr. or Mrs. Witts or Wittis. Pam says, no way. The jury saw through Alex. The jury saw through Alex. And I tell you, Alex was up there really bearing his soul. I mean, he was admitting a lot of things anyway. Um, so because he admitted to most of the financial crimes. I saw that. I saw that part of his testimony. So I think he was thinking, and maybe his lawyers were thinking that, um, yeah, I committed financial crimes, but you didn't prove and can't prove that I committed murder. And that's not what we're here for. We're not here for the financial crimes. Lock me up for that. But I did not, I heard him say, I did not murder my wife and Paul Paul. Kept calling him Paul Paul. All right. So, yeah, Samantha Jordan says exactly. So I think she agrees with Pam. Um, well, we're having a back and forth here, wondering why his son, here's a question, wonder why his son didn't make a plea on his dad's behalf before the sentences. We addressed that, Samantha Jordan, and it's a great question. We would have, okay, if we were representing Mr. Murdaugh or Murdaugh, whichever it is, we would have certainly had the son and anyone and everyone else, maybe several of his law partners, I don't know. We would have had them to to testify during the sentencing phase about, you know, how great he is. All that stuff about character that goes out the window when you're doing the sentencing phase. Um, but we don't know why. We just don't know. We don't know if in South Carolina they can't do it. We have no idea. Here in Texas, oh boy, we would have done so because the son testified in the guilt and innocence phase. So I agree with you. I'm wondering too, why didn't he testify during the sentencing phase? Um, I don't know. We would have done so here. Any thoughts on
And
that,
then
Chloe?
another thing too is he admitted to having drug addiction, addiction. I would have brought that up in the sentencing as a way to try to garner favor and sympathy. I mean, a lot of people's family members are suffering from opioid addiction, drug addiction. So allow him to get treatment and instead of you know just throwing the book at him for things that could have occurred because of his addiction. So yeah, we don't know why they did not go into a lot of detail in trying to plead on his behalf.
Yes, and Pam said she thinks that Alex is denying that he was at the kennel was just too damning, just a bridge too far for the jury. Um, and then him admitting the financial crimes, and I heard one of the jurors say after the sentencing that he didn't seem to be very remorseful. Some tears here, some tears there. Um, you know, Different people handle that differently, but I sort of agreed with that. I mean, wow, if someone had, can't even think about that. Um, there'd have been a whole lot more, not remorse, but just emotions. You know,
Yep.
remorse would suggest he did it. Yeah, yeah. Folks are debating it. Matthew Jordan says don't understand how he could have killed um, two people within 15 minutes apart. It's another great consideration. Um, I mean, if you murder one, then how do you space the next murder 15 minutes apart if you're all in the same room? Um, Unless you're holding the person at gunpoint, you know. And I look, I just cannot fathom this whole thing. I cannot, in my mind, make any sense out of this. Trying to explain how this could have happened. That I wow, Chloe, it leaves you speechless. You know.
Don't talk to the police. You have the
Yes.
constitutional right to remain silent. Do not talk to the police if you are the subject of a criminal investigation. Don't do it. Ask for an attorney and shut up. Don't say anything. You have a right under the Fifth Amendment to not incriminate yourself. Use it, exercise it.
So maybe they will understand it in this voice. Do not talk to the police. Do not put the rope round your neck talking to the police. Maybe
Mm-mm.
they'll understand it in this voice.
Don't talk to the police. whatever you do,
Don't do it. Like the video. We'll be back next Saturday, y'all. Thank you for joining us. Thank you for all of the comments. We love this community. We love you, Rebels. Please share this video with your family and friends if you got something out of this. We will be back next Saturday to talk about the next trending topics and information. Peace. Hey.
That Corbin and Corbin legal team fighting for the rights of the people. That father-daughter team investing in the youth when the system ain't treating them equal. Providing truth for our people, we able to reach them. So anytime you get accused for a crime and Lord knows you ain't do it, we here to get you through it. Exemplifying prudence and glorifying God, making sure you're compensated for other people's doings. Our vision is to be one of the best. We're small enough to focus on your matter throughout the neighborhoods of Dallas. Working constantly and making sure your rights are protected. A firm team of lawyers, aggressive, effective. A team that has your back in the courtroom. Two well-spoken black lawyers in the courtroom. Investing time and resources when it's evident that you were treated wrong. Now you walking out of Dallas courtroom with a settlement. Corbin and Corbin, the father-daughter legal tag team that has your back in the courtroom. Our purpose is simple. To obtain a favorable outcome for each client and glorify Christ in all we do. Our vision is to be one of the best and most